This lesson will focus on contracts and representation. Within this lesson, we will discuss types of contracts, elements of a valid contract, legal capacity, as well as special doctrines of contract law. And then we will talk about breach of contract, as well as defenses and remedies to a breach of contract. Let's first start off by discussing the variety of contracts. Now, a contract is a legally enforceable promise or set of promises between two or more people. So that's a basic definition of a contract. And if there is a breach of contract, which means that one or more parties do not fulfill their promise or set of promises, this will typically result in a remedy, usually money, or a demand for performance. Now, within the sport industry, contracts that we are typically seeing include employment agreements, vendor agreements, sponsorship contracts, naming rights agreements, facility and equipment leases, warranties, etc. So this is a very relevant topic to our industry. Now, while those are different types of contracts based upon their substance, there are actually different types of contractual agreements that we should consider. The first is expressed contracts versus implied contracts. As you can see on this slide, express contracts are when the parties clearly state the terms of their agreement, either verbally or in writing. Now, in comparison, an implied contract is when a party's conduct or performance is indicative that an agreement exists. However, there is no proof of any formal exchange of promises. So when comparing express versus implied contracts, the courts have found that an express contract is easier to prove the existence of the contract because the terms of the contract are expressed in writing is honestly the best way to prove the existence of a contract. Oral contracts are also enforceable in a court of law, but once again, establishing the existence of a contract and the terms of a contract becomes more difficult for the party that's trying to enforce the contract. When in doubt, make your contract in writing. Strongly encourage that as a best practice because oral contracts and implied contracts can be difficult to prove. Now, a court is not going to distinguish or weigh express and implied contracts differently. The court's role is merely to assist the parties in retaining the original or intended agreement. However, that is most clear when it's in a written document. And there are actually some state and federal regulations that require certain agreements to be in writing, which we'll talk about when discussing special doctrines. Another type of contract distinction is bilateral versus unilateral. And you'll see on the graphic on this slide that a bilateral contract is when both parties make a promise to each other. So it's an exchange of promises. I promise that I will give you money in exchange for you performing this service for me. You promise to perform this service for me. Within sport, most offers involve a bilateral contract because, once again, it is easiest to prove that a contract exists when you have evidence of promises of both parties. A unilateral contract is where the offerer will make a promise to the offeree if the offeree is able to perform some specified action. Now, this can be a unilateral contract can be expressed. It can be stipulated in a written document. However, the offeree is actually unable to make a promise that they can perform a specified action. An example of this might be a So let's think about racing. In a 5K race, the race organizers can promise a prize for the first place winner, let's say $500 for the first place winner. However, the runner, who would be the offeree in this case, cannot promise to win first place. That's just not a performance that is under their control. However, if they do win first place, if they do meet that specified action, then they have legal rights to the promise that was made to that $500. So that's the difference between a bilateral and unilateral contract. When thinking of a unilateral contract, just consider, can the offeree actually promise to do something, to do a very specific action that the promise by the offerer is stipulating? So is it under their control is something that I consider. And then another category of different types of contracts involves the legality of the contract. So is a contract valid, void, or voidable? Three different situations. A valid contract is what we're shooting for. That is a legal contract in which a court will enforce the contract and grant some type of relief to the plaintiff if the defendant is found to be in breach of contract. So a valid contract includes all necessary elements of a legal contract and is enforceable in a court of law. We want all of our contracts that we engage as sport managers to be valid contracts so that the court can legally enforce that contract for you. Now, there are also void contracts, and a void contract, in that case, neither party is obligated to perform or fulfill their promises. An example of a void contract is a contract that actually doesn't meet all the necessary elements of a legal contract, or a contract that is involving illegal action, or a subject matter that violates public policy, like in the intentional torts lecture when we talked about the bounty hunting culture in the NFL. You cannot legally bind someone to perform something that is against the law. So those contracts would be void, which means that it is not enforceable in a court of law. And then there is a voidable contract. In this case, the contract is only voidable by one party, which means that one party has the option of canceling the agreement or getting out of the agreement without being liable for breach of contract. Where we most often see this is with parties that lack legal capacity to enter into a legally binding contract. Which we'll talk about in a moment. Parties that lack capacity, for example, minors is usually the best example in our industry. If a minor signed a contract, well, that would render the agreement voidable by the impaired party who is the minor. So the minor could get out of that contract, cancel the agreement without being liable for breach of contract. So it's unenforceable against the party that's lacking capacity, so this impaired party. However, note that for a voidable contract, it actually is enforceable against the party with capacity. So voidable contracts, typically only one party can cancel the agreement, which means that the other party is still bound by the contract. The example that we see on this slide in terms of valid, void, and voidable contracts is a lawsuit that was back in 2019. Zion Williamson, who was playing for Duke University, he played one season at Duke before becoming the #1 draft pick in the 2019 draft. He sued Gina Ford and her marketing company, Prime Sports, in an attempt to terminate his marketing agreement with her company without breach of contract. So essentially, he took her to court to try and make the contract void so that he would not be bound by the contract, but also liable for breach of contract. A little bit of background information is that at the time that Williamson engaged Ford's marketing company, he was still a student athlete for Duke, which is in North Carolina, and Ford was not a certified agent in North Carolina. And then also, the agreement did not include the required warnings under the law of engaging an amateur athlete, a student athlete. And so, for these reasons, the court actually did terminate this contract and find it void because it didn't include all of the necessary elements of a contract. So those are different types of contracts that will really inform how the courts examine a breach of contract. Once again, I encourage you in the sport industry to create expressed contracts that are valid, and most often they will be bilateral. When it comes to a valid contract, so this is one that is enforceable in a court of law, this contract will be an agreement between two or more parties in which at least one party has made a promise to a second party. This second party has accepted this promise, and the acceptance is based upon consideration that is being exchanged. Let's break this down a bit further for you. So in a valid contract, there should be three elements. There should be an offer made, consideration exchanged, and acceptance around the terms of the agreement. With an offer, as you can see on this slide, an offer is a conditional promise from the offerer to the offeree. So the offerer is the person that is making the offer to the offeree. And this is the person to whom the offer was made. So for example, you'll see in this outdoor adventure business on the picture on our slide, the customer would be the offeree and the business would be the offerer, making a promise to, if you purchase this piece of equipment, we will supply this equipment. If you pay this, we will give you this. So the offerer makes the offer. The offeree needs to accept the offer. When making the offer, the offerer demonstrates a willingness to enter into agreement with definite terms that leaves the offeree in a position to respond. So once the offer is made by the offerer, the power is now in the hands of the offeree to either accept or reject the offer. The offer as made must be accepted by the offeree to whom it was made to constitute an acceptance. It can be accepted by any other party. And both parties must mutually assent to the fundamental terms of the agreement. And we'll talk about that a bit more with acceptance. The second element of a valid contract is consideration. And this is what is being exchanged of value between the parties, what is being promised and agreed to. While consideration is often the payment of money, typically, consideration can also be an agreement to do something. So this might be in an employment contract, your duties and responsibilities that you are agreeing to in exchange for your salary and benefits. Consideration may also consist of what you're not going to do. So for example, once again, in employment contracts, we might see a covenant not to compete, what you will not engage in if you leave the contract early. Coaches, I'm not going to recruit from this regional area if I break my contract and accept another offer at another institution or team. So consideration is really anything that is considered of value to the offerer and the offeree. Now you'll see in the notes there are a couple of links, and I loved from SB Nation this article of the 9 biggest and 3 weirdest sports contracts of all times, which talks about the consideration exchanged. So they highlight some of the largest contracts in sports history, such as Alex Rodriguez's 10-year $275 million contract with the New York Yankees in 2008. There was Robinson Cano, 10-year, $240 million with the Seattle Mariners contract. So huge contracts. There were contract extensions that are listed here, like James Harden had a 6-year extension for $226 million with the Houston Rockets. So we are seeing that consideration often involves payment of money by one party. But you'll also notice some weird contract clauses that I found was just hilarious. So there was one where, let's see, Stefan Schwartz, there was a clause in his contract that he has to stay on Earth, which is just interesting. So that's kind of something you have to do and something you cannot do. Because this soccer player, Stefan, was well known for his love of outer space. And the English Premier League team knew this and they were concerned about it. So in 2002, they added an addendum to his contract saying that he must remain on Earth. And this was just a means to protect their investment. But I thought that consideration was just super fascinating. And then the third element of a valid contract is acceptance. And this is when the offeree accepts the offer. And by that, they are accepting all fundamental terms of the agreement. This offeree can accept the offer through signature, verbally, or through performance. So once again, this gets at express versus implied contract, and expressed, which means accepted by signature, is always the strongest form of acceptance. Now, when accepting an agreement, the offerer cannot change the original terms. So if an offerer is going to make a counter offer and engage in negotiations with the offerer, which happens all the time in sport and is strongly encouraged to make counter offers and engage in negotiations so that your contract is mutually beneficial to both parties, you must know that a counter offer actually terminates the offerer's original offer and creates a new offer. So it is not a form of acceptance. It actually switches the role so that the offeree who makes the counter offer is now the offerer. And now the offerer, or original one, has the power to accept or reject the counter offer. The picture that you'll see on this slide with Dak Prescott, there just was an article I was reading back in 2019 regarding his negotiation with the Cowboys and how he was seeking $30 million in his new contract. And it just describes his experience with negotiating and offering counter offers. It is a learned skill set that I encourage you to engage to make sure that contracts you sign are in your best interest. Here's a graphic that I found was really helpful in detailing the process, because these 3 elements are interdependent and actually follow a distinct process. So first is the offer is made, and you'll see the different types of contracts considered on this slide. So when an offer is made, can the offerer actually return a promise or not? So that's bilateral versus unilateral. How is acceptance going to be stipulated? Is it going to be expressed versus implied? So these are some different considerations when making an offer. In the offer, there should be consideration that is outlined. So the offerer is the first party to determine the fundamental terms of the agreement. And then next, we consider, was this offer with consideration specified, accepted by the offeree. Now, acceptance can be through expressed verbally or in writing, or it can be through one's performance in terms of an implied contract. Now, the C, termination before acceptance, are just a few extra details that I want you to be aware of in terms of it is possible for that offer to be terminated before acceptance is ever made. So there are a couple of different details that you should know about in regards to acceptance. And one is regarding lapse of time. So an offer may be withdrawn prior to acceptance. So you know, so as an offerer, you have the power to withdraw your offer unless within your offer it specifies a period of time in which the offer is open. So it specifies how much time the offeree has to accept the offer. So just be mindful of if that is a term within your offer, or if you have complete freedom to withdraw the offer if you wish to do so. Now, the offer must be accepted within this period of time that is designated, or generally within a reasonable period of time if no specific time has been designated. If you do not accept within the period of time specified, then that lapse of time could actually terminate the contract and revoke your power to accept the contract. There's a mailbox rule that you should be aware of. Now, we are in an age of technology, and so we are seeing contracts mailed less and less, especially with DocuSign now. However, if an offer is accepted, you should know that it is accepted immediately upon when it is sent. So it's called a mailbox rule because contracts used to be sent through the mail. So as soon as you posted that mail, the contract would be considered accepted. But now we can also keep in mind when it is emailed, faxed, when the DocuSign is completed, this all would constitute immediate acceptance. And if the accepting party, so this is the offeree, refuses to accept the promise exactly as the promise was made by the offerer and requests that the offer be altered. So we're saying that they're not agreeing to the fundamental terms and they want to make a counter offer. This is actually considered a rejection by the offeree. If the offeree wants to alter any terms of the contract, the original offer is considered dead and can no longer be accepted. So the counter offer takes us all the way back to the beginning of making an offer. Now, a few other ways that a acceptance can be terminated would be understandably by the death of the offerer or offeree, and then also the validity. Is this a valid contract or is it a void or voidable contract? Because that would also then influence power to accept. Next, we're going to talk about a few different critical components of contract law. What influences the legality of a contract and the power of parties? So let's start off by talking about legal capacity. Parties to a contract must possess the capacity to comprehend the terms of the contract and how those terms affect parties' legal interests. So legal capacity, honestly, it is in the best interest of both parties because you are making sure that those parties are able to comprehend what they are signing, what they are agreeing to. Now, deciding whether someone is legally competent or has the legal capacity to make decisions, that is really based upon the seriousness of what is at stake and might involve medical professionals. It might involve the court system. But legal competence, it's just really important to make sure that both parties are protected when entering into a legally binding agreement. And on this slide, you'll see the individuals that lack legal capacity. So minors, anyone under the age of 18 years of age in the United States do not have the legal capacity to enter into a binding contract, and therefore their parent, guardian, or caregiver would sign the contract on their behalf and be their legal representative. A couple of other individuals who do not have the legal capacity due to their competence would be those who have a medical condition that diminishes their mental competence and ability to understand the legal terms of an agreement. And then also those who are under the influence of alcohol and drugs. Now, they need to be so intoxicated, for example, that they are unable to understand the nature of the agreement that they're agreeing to. And if one of the parties that is entering into a contract lacks capacity, so they either are a minor or they have diminished mental capacity, well, in that case, contract law renders the agreement voidable by the impaired party. So that gets back to the valid, void, voidable contracts. And in this case, it's a protection for the impaired party. So it makes it voidable. But also, just so you know, I love this next slide because it reinforces that legal capacity is a human right that everyone should be able to enjoy. So everyone should have the power to make decisions for themselves. And legal capacity is different from mental capacity. Legal capacity is a legal right to make decisions that are recognized and can be enforced in a court of law. So everyone has some form of right to their legal capacity. However, some people just may need additional support to make their decisions and exercise their legal capacity so that they are protected. So once again, minors, it's typically their parent or guardian who is going to be entering the contract on their behalf. For individuals with diminished mental capacity, they will typically have an authorized legal representative, which is just someone who is legally authorized under state and federal law to make decisions upon their behalf for their benefit. But I just love how this really reinforces that legal capacity is a human right that everyone should enjoy. People just might need a little extra support when making decisions on their behalf. There are a few additional doctrines that I wanted us to consider pertaining to contract law. So the first one is promissory estoppel. Now, there are times when a party can enforce an agreement because they relied on a promise, even though the formal agreement may be incomplete. Courts will consider the fact that one of the parties relied on the agreement. It created this detrimental reliance and there was an injustice. So the plaintiff would have to show that there was a promise that they relied upon and there was damage because of that reliance. So a promise is binding as a contract when it has been relied upon by one of the parties and the reliance causes substantial harm. And often this reliance needs to be one that could have been foreseen by the offerer, for example. So when I think of promissory estoppel, I often think of contracts and contract extensions and contract renewals, where if your company has been engaging in a contract with another company for years and years, and your contracts have been renewed and you're currently in negotiation for an upcoming contract and you're spending time preparing to fulfill that promise and that contract falls through, you never reach agreement, but in your preparation to fulfill that contract, you experience substantial harm based on the time, the money, the resources that you were putting into just preparing to fulfill that contract, such as if you've been hosting a particular tournament series every single year for a very long time and you're preparing to host it again, but that contract falls through, well, guess what? You were still harmed in the process and may be able to get a remedy from the courts. Another doctrine is the parole evidence rule. And this confirms that the final contract is final. It is the complete final statement of the parties' agreement. So any earlier versions of a contract or so counter arguments, any negotiations that were made orally or through written documents, basically any table talk, anything that happened before the final contract was agreed to is inadmissible in court and cannot be enforced. It's really just intended to address any breach of contract disputes. And just so you can interpret the cartoon on the bottom correctly, an integration clause is a clause that is often included in a final contract that just explicitly declares that that contract is the complete and final agreement between the parties. So it indicates that anything prior to that contract is null and void. And then another special doctrine, which we briefly talked about when discussing the expressed type of contracts, is the statute of frauds. And this is a legal doctrine that is intended to prevent fraud and unkept promises and really encourage that promises be fulfilled. And in order to try and mitigate breach of contract and uphold the fulfillment of promises, the statute of frauds stipulates that certain transactions have to be in writing in order to be enforced in a court of law. Now, the cartoon of my legs, just so you know, this is a really common acronym in law school, just as a way to help understand what types of contracts need to be signed. So needs to be in writing to be enforceable. So I love the marriage is the M. Any contract that cannot be performed within 1 year. So year is the Y. Agreements for the sale or lease of land, L is the land. An execution of a will, so that's the E. And then any goods that are over $500, that sale has to be in writing, so that's the G. And then the last one is anytime an executor promises to be personally liable for another party's debt, is the S. So I don't know, that might be a helpful way for you to remember which contracts have to be in writing. Now, if one or both parties fails to fulfill one or more of the promises agreed upon in the contract, then that would constitute a breach of contract. And the degree of non-performance, so to what degree were the promises not fulfilled, will dictate the remedy sought by the non-breaching party. Now, in this case, if a lawsuit is filed and the non-breaching party, who would be the plaintiff, sues the breaching party, they do need to prove that it is a valid contract, which means that it's enforceable in a court of law, that they performed their promises. So you can't also be in breach of contract. You have to prove that you performed your promises. The defendant failed to perform their promises, and as a result, there was an injury suffered. So typically this is an economic loss due to the breach of contract. And you'll see on this slide 2 recent lawsuits for breach of contract. This first one is UCLA versus Under Armour. So UCLA sued Under Armour for ending a $280 million sponsorship deal. So this 15-year sponsorship deal was signed in 2016 and was the largest in the history of college sports at the time. So this is a huge, huge contract. And in exchange for the $280 million, UCLA's student athletes and personnel would also be able to have access to Under Armour products exclusively. So the school sued Under Armour for ending their sponsorship deal. Under Armour had said that they discontinued their partnership with UCLA because they were paying for marketing benefits that they were not receiving for an extended period of time, essentially alleging that due to COVID-19 and this pandemic, they weren't getting out of the deal what they agreed to be getting out of the deal. Because guess what? Sports got like stalled. Crazy. I mean, COVID-19. Of course, there are going to be limitations with UCLA and their use of the products and their marketing. Anyways, I have my own personal opinions, but there is a lawsuit that UCLA is suing Under Armour for alleging that their argument of COVID-19 is not a good enough reason to break this agreement. Another breach of contract lawsuit that you'll see on this slide is Canelo Alvarez, who's suing DAZN and his promoter Oscar De La Hoya for breach of a $365 million contract. Now, in this lawsuit, he is trying to seek $280 million in damages for failure for his agent to secure really key fights. And there was a particular fight back in September 2020 that was supposed to materialize and was supposed to be one of the most lucrative fights in sports. And yet that fight wasn't secured. And so he is suing his agent for breach of contract. So those are just a couple of recent examples of how relevant breach of contract is to our industry. Now, if you are, well, let's hope that you're not the one being sued. So let's think of it as if you were the plaintiff. If you experienced a breach of contract and the other party who allegedly breached their contract have a few different defenses that they could use. So the first one is attacking the validity of the contract. For a contract to be enforceable in a court of law, it must have all three necessary elements of an enforceable contract. So it must have an offer. That offer must include consideration exchanged, and that offer must be accepted by the offeree. Also, that offer should be valid in that it is not involving any illegal activity, or it does not include consideration that is against public policy or just against the benefit of society as a whole. So is it a valid contract? Because if it's not, if it's void or if it's voidable, the defense could potentially get out of liability for breach of contract. And then also mutual mistake. So this is when both parties were mistaken as to the subject matter of the contract. And so if both parties are thinking something completely differently about the consideration, was there ever an agreement? If they actually were on completely different pages about the contract terms. So when there is mutual mistake, so this is a bilateral mistake, the defendant can get out of a contract without being liable for breach of contract. However, the mistake has to be mutual. They have to have had complete misunderstanding of the terms of the agreement, meaning that an acceptance actually was never formed. If there is a unilateral mistake in which it is a very explicit and clear contract that a standard party would be able to understand, and you just were mistaken about it, unfortunately, you will still be bound to it. And then a couple of other defenses that could be used. One is in regards to fraud. So courts may rescind contracts, which essentially means to cancel the contract, if it involves fraud in the inception of the contract or inducement to sign the contract. So essentially, in order to enter a legally binding valid contract, you must enter it voluntarily. That is such an important element or an important piece when it comes to contract law. You cannot be coerced or induced into signing the contract. And then once again, we're seeing that contracts are only enforceable for parties that have legal capacity. So if one or more of the parties lack legal capacity, they're a minor, they have diminished mental capacity, then the contract can be voidable by that party with that is impaired. So they wouldn't be liable for breach of contract. If the plaintiff is able to prove breach of contract, there are a number of different legal and equitable remedies that the courts may grant. So if a court finds that a party has breached a contract, it will grant relief in order to attempt to place the non-breaching party, so this is the plaintiff, in the same position as if the contract had been performed. On this slide, you'll see a list of legal remedies. So this is when the court is awarding the non-breaching party a monetary award for the damage incurred due to the breach. Now, we've previously reviewed compensatory and punitive damages. Compensatory is essentially a damage that is equivalent to the loss of the bargain, whereas punitive damages is meant to punish a defendant's reprehensible behavior and trying to deter others from acting similarly in the future. I wanted to note, though, that punitive damages are very rare in contract law. They are much more common in tort lawsuits. And then a couple of other different types of damages. One is consequential, which it actually is based upon damages that have yet to occur, but that will result later based on the breach of contract. So an example of a consequential damage might be if you break your employment contract early. Well, guess what? Your employer now has the future task of spending the time and money to market that position, to recruit individuals, to interview, to hire. That's a significant amount of time and resources that they are having to invest because of your breach of contract. So sometimes the monetary remedy might reflect future damages, consequential damages due to the breach. And then there's nominal damages. This one I find so funny. In this case, there really isn't much of a injury. There isn't really any significant economic loss. These cases are often motivated by principle, right? You broke our contract. They want their day in court, but there wasn't a significant injury here. And so the courts will often award damages. So this is the legal remedy and the amount of a few dollars. Seriously, y'all, I have read cases where the remedy was like $2. So that one cracks me up. And then there are liquidated damages. And this is the only legal remedy that is actually not determined by the court. It is determined by the two parties. So liquidated damages is a clause that is specified and agreed upon within the contract. Should either party fail to perform its duties under the agreement, the liquidated damages will specify how much that party owes. So if I fail to perform my duties, I agree to pay you this amount of money. That would be liquidated damages, which we often see in, a lot of different sport contracts. However, the courts will examine this clause just to make sure that it is equitable. So the amount of money specified within the contract has to be reasonable in terms of the performance that wasn't fulfilled or those promises that weren't fulfilled. And then there are non-monetary remedies. So these are considered equitable remedies. And the slide shows a few. Specific performance. This is when the courts require the breaching party to actually perform its duties under the contract. So, hey, party A fulfilled their part of the contract, they performed this service, you are required, bound by law, to pay for that service, to perform your end of the deal, which is often monetary. So typically we see specific performance when it's requiring a breaching party to provide some type of um, tangible benefit. Courts will rarely order specific performance for a breach of a personal service contract because it is considered involuntary servitude. Basically, a courts cannot order someone to to perform a service. So we're thinking like in an employment context. I can't require you to perform your job because it's actually considered slavery in that case. So most of the time we see specific performance with more like you need to make this payment, you need to give this product, things of that nature. And the plaintiff in this case would need to demonstrate that there's no other appropriate legal remedy to make them whole. Money is not good enough. I need the specific performance in this case. And then there's an injunction, and this is when one party is actually prevented from performing its duties under the contract. And typically issues when there is evidence that a party will be irreparably harmed if relief is not granted, this is where we see an injunction. So actually performing your duties will result in harm to you. So in this case, the courts can actually prevent you from performing your duties. And then the last one is rescission and restitution. Contracts that are, as you mentioned, a void, right? They're unconscionable, they're illegal, they're fraudulent, or perhaps there was a mutual mistake between both parties. In those cases, the courts will rescind the contract, which basically means to undo it or to cancel it. And rescission most often involves restitution. So what does that mean to undo the contract? Well, courts will order restitution where it requires all parties to return the consideration that was going to be exchanged and any benefits that were going to be reached from the agreement to try and get both parties back to their original position. So these three are all remedies that don't necessarily involve money, but also are ways to get the non-breaching party whole. I loved this life of a contract flow chart because it really walks you through how do you get from offer to acceptance to an enforceable contract and law. So you can follow this flow chart to see how we work from an offer that if it's rejected, well, it stops there. Is there a counter offer? Well, it goes back to an offer. Is it accepted? Is there consideration or not? Because if there is consideration, it's a contract. If there's not consideration, it's a gift. And then if there is a contract, you need to perform your side of the contract for it to be enforceable. However, if it's a void contract, then it's not enforceable, or if it's voidable, you don't need to perform. And if it is enforceable and there's a breach, you have certain remedies that we've talked about. So this is just a great flow chart to kind of take you through what a contract looks like. But I also wanted to take an opportunity to give you an example contract and walk you through a couple of key terms that we often see. So let's look at Chris Holtman's employment contract with Ohio State. I'm going to change my screen so we can check out this contract. So in this contract, you will see at the very top, we're seeing the offeror and the offeree. So Ohio State is the offerer who is making this offer to Christopher Holtman, who is the offeree and has the power to accept this offer. This is an employment agreement, and it is considered an expressed contract because it is in writing, and it is bilateral because both parties have the power to agree to a promise. So that is the type of agreement, and it is valid. This could be enforceable in a court of law if there was a breach of contract. Now, within this employment contract, you'll see common terms that are found within a contract. So the terms are essentially the consideration. So the fundamental terms of a contract is the consideration that is being exchanged and agreed to. So here you will see a basic description of Chris Holtman's employment in terms of what his overarching responsibilities will be as the head coach for the Ohio State men's basketball team. Employment contracts typically always will include a term. So what is the length of the contract, which here we will see it's from 2017 to 2025 is the term of the agreement. So all of these components are consideration that was mutually agreed upon by both parties. And then a important part of an employment contract is the compensation. And in this case, the compensation, it has a number of layers. So we are seeing the coach's base salary of $850,000 a year is the base salary. However, we're also going to see that Coach Holtman is going to be compensated for his responsibilities to engage the media, promotions, and public relations. And this stipulates all of Coach's responsibilities pertaining to the media. At the end, I think it says how much, about $1.3 to $1.4 million a year is what Coach is getting for the media, promotions, and public relations. So you'll see that base salary is really just a starting point because the coach gets a lot of additional compensation and benefits. For being a part of the Coca-Cola sponsorship, Coach is getting compensation. For being a part of Ohio State's apparel, shoe, and equipment contract, Coach gets compensation, as well as a supply of athletic apparel and equipment and footwear. And then Coach also gets certain bonuses if the team performs. So winning a Big Ten conference championship, the coach will get $20,000. Participating in the NCAA postseason tournament, the coach will get $40,000. So exceptional achievements, this would be a great example of a unilateral promise because the coach can't promise that they're going to win the Big Ten conference championship. However, if the coach does win the conference championship, Ohio State is bound to give the coach this amount of money. So this would be an example of a unilateral aspect of this contract. And then based on the team's grade point average, this is a nice little bonus. Okay, I say little figuratively here, but the coach will get compensated for that. So lots of different payments for the different types of responsibilities. I mean, coach also gets other fringe benefits like money towards automobiles, for example, that you'll see just down here. The compensation is often a huge component of the employment contract. Love this part, jet aircraft. I would love to have a private jet aircraft in my employment contract, a full golf membership, so lots of fringe benefits here. And then this is another huge aspect of a employment contract is where the consideration is specifying the performance responsibilities of Coach Holtman. So this is specifying an action or several actions that the coach has to fulfill in regards to like evaluating, recruiting, training, coaching the team while assuring their welfare. So all of these terms are responsibilities that the coach has to fulfill. Adhering to Title IX, NCAA regulations, those are really important. We'll keep scrolling, see if there are any other key elements I wanted to point out. So all of these are different terms that the coach has agreed to. Within an employment contract, another consideration is termination. So these are all of the reasons why Ohio State could potentially terminate Coach Holtman's contract without being in breach of duty. So for example, if the coach violates NCAA regulations or university code of conduct or any state and federal laws. Well, in this case, Ohio State can terminate the contract without being liable for breach of contract and having to pay liquidated damages. So this will outline all of the different clauses, which there are a number of them. And then you'll see down here, termination by Ohio State other than for clause. This is where we're going to see the liquidated damages. So if Ohio State wants to terminate the contract in advance, or if Coach Holtman wants to terminate the contract in advance, this is their agreement of the liquidated damages that they would pay for breaching their contract. And this is what is agreed to. So this section talks about what Ohio State would pay. And then if we scroll down, we'll also see what the coach agrees to pay. Termination by coach, for example, which just talks about basically paying for the compensation. I think that he was supposed to, yeah, so like paying an equivalent of the base salary is an example of the liquidated damages. And then after liquidated damages, we see reasons for, hey, death or disability, reasons why you might be able to breach your contract but not be liable for it. And then there are a lot of other different terms that are just wrapping up this contract, but need to show you that it's expressed. Let's get to that signature page. So right here, we see that it is a expressed contract. And coming back to our PowerPoint briefly, the last thing I want you to consider is putting this all together. I encourage you to examine a recent contract you have signed. It might be a waiver, it might be a rental agreement, it might be the purchase of a vehicle, an employment contract. I encourage you to examine it and try and identify the necessary elements of a valid contract within your contract to put this all together.